What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we've got some updates on Karen Reed's jury. It continues to grow. We have kind of an idea maybe of when this jury will be seated and the trial will actually start. We've got another ruling from Judge Cannone on an objection to a Commonwealth expert. We're going to dig into that as well, and we're going to watch a little clip from jury selection so we can see how the lawyers are starting to vibe with the jurors. Make sure you guys hit that like button. Make sure you're ready to talk about this case because we're gearing up. Let's get to it. All right. So the first thing I want to look at is it's midday here when I'm recording this. You'll probably be watching it at night, but I want to take a look at two Twitter pages. These are the two Twitter pages that I think, as far as reporters go, are putting out as much information as anybody else. So I've been kind of keeping track of them and a few others. But Christina Rex said that 4 total jurors have been seated for Karen Reed's second trial. 2 picked this morning and 2 yesterday. So if we just do some math, and I think they want to pick about somewhere around 16 jurors. And if they have 4 after 2 days, you would think they'll be done in 4 days. So end of this week, beginning of next week. But some days they only pick 2, like yesterday. Some mornings they'll pick 2. So if we take kind of a 2 to 4 juror picked per day, that creates a scenario where I think there's a pretty good chance by the end of next week that we could have our jury sat in Karen Reed's case. Now, of course, it can take longer or shorter than that. I would also think if we get close to the end of next week, Judge Cannone will send everybody home and then we'll come back the morning of, what is it going to be, April 13th, something like that, whatever that Monday morning is, for opening statements. So I still think we start this trial in April. It may be closer to late April than mid-April, but it's moving faster than I would have expected it so far. Let's look at some of her other tweets. Now begins voir dire. This is a private process. I can observe but not hear. Individual jurors are called to sidebar for interviews with lawyers and the judge. Right now, they're calling up jurors from yesterday who hadn't been questioned. Some stats. Last trial, this is interesting, I thought. 75% of jurors knew of the case. Yesterday, 86% of jurors knew of the case. Today, 89% of the jurors know about the case. So mid-70s last trial, high 80s this trial. So we're getting close to 90% of people have heard about this case, which if I was going to say higher or lower, I would have guessed it was going to be higher than that, right? I would have thought it would be low to mid 90s. Almost everybody would have heard about this case. Also of note, 40 people here say they have a substantial hardship, plane tickets, surgery, etc., that would make them unable to be a juror. So most of my trials are around a week. We've had some that have gone a couple months. And when you even have a week-long trial or a 3-day trial, whatever it is, you have people that have childcare issues, hospital stays, doctor's appointments they can't miss, plane tickets, vacations planned. So when you have a 6+ week trial, you can imagine if you had a really important doctor appointment 4 weeks from now, you don't want to cancel that because of this trial. If you're going on vacation 3 weeks from now, you don't want to cancel that. Some of them are prepaid and you can't cancel it. You lose your money. So the longer a trial is, the more difficult it is to deal with hardships. And we read in the jury questionnaire, they asked so many questions about the media scrutiny and all the eyes on this case that that's just going to add to people thinking of hardships they may have if they really don't want to end up on this jury. And the longer a case is, the more seriously a judge has to take a hardship, because the worse the hardship is, the more a jury or a juror specifically may be distracted, may not be able to put their full focus on the case. And that is not a fair trial for Karen Reed or for the Commonwealth and the people of Massachusetts. Okay, this was from today. Of the 87 potential jurors, I think there was around 90 yesterday as well, 77 had heard of or discussed the case. 38 have formed an opinion. 14 feel bias toward one side or the other. And people are asking the difference between bias and opinion. We talked about it a little bit yesterday. Opinion can be just opinion about anything. Opinion can be something that with more facts, you can change your mind. A bias usually means you're firmly in a camp. One side or the other, as we like to say in jury selection, starts a few steps behind. And if you start a few steps behind, you are struck. If you say, the defendant starts a few steps behind the Commonwealth, then you can strike them as a juror, as the defendant. In a civil case, if either side is a few steps behind, It depends on the jurisdiction, on what kind of questions you're allowed to ask. But if somebody is already biased towards one side or the other, usually that is enough for a cause challenge. Some judges in some jurisdictions will allow lawyers to try to rehabilitate those jurors, to make them say, oh, yeah, I can put that aside and I can be fair and impartial and I can just watch what happens in this case and I'll pay attention to the evidence and I will not hold that bias against one side or the other. But once they say it in open court, once they admit it, it's usually pretty difficult to get around it. Let me see if there's anything else. Day one is wrapped. 62 potential jurors were questioned. So that leaves, I think, right around 30 that did not get questioned yesterday. 2 were seated, 1 man, 1 woman. All right. Yeah. And she says, Victoria George introduced herself as one of the attorneys. We are going to watch that together. All right. Now let's take a look at Ted Daniels' Twitter. And he says, 2 more jurors have been seated in the Karen Reed trial, bringing the total to 4. Jury candidates get to break for lunch and will return around 1 p.m. Some will go home and come back tomorrow. So as you see, just because they bring about 90 jurors every day doesn't mean that they're going to question 90 jurors every day. They're going to get through as many as they can possibly get through and pick as many jurors as they possibly can. But it seems like they're moving right along. Nowhere near compared to Lori Vallow's case. Also a very high profile case, also a second-ish trial for Lori Vallow. They've already got the jury picked and they're starting opening statements on Monday. So it can go quickly, especially when you don't have criminal defense attorneys. That's probably the biggest difference. Is I cannot tell you how much more difficult it probably would have been if Lori Vallow had private criminal defense attorneys representing her instead of trying this alone and representing herself. So speaking of private criminal defense attorneys, let's now turn our attention to the actual courtroom today. And take a listen to Karen Reed's team and the Commonwealth's team of lawyers introducing themselves to the jury. And there's some things we can take from this about vibes, about building camaraderie and how it works, what can rub some jurors the right way, what can rub them the wrong way. And we'll discuss that as we listen to them introduce themselves.
At this point, I'm going to ask the lawyers to introduce you to themselves, and I'm going to ask that the defense counsel introduce their client, starting with the Commonwealth, please.
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Hank Brennan. I have the privilege of representing the Commonwealth of Massachusetts. Along with me in this case, there are 2 other attorneys. I'd like to introduce both of them. My far right is attorney Laura McLaughlin. And beside me is attorney Adam Lauer.
Thank you. For the defendant, please.
So I know he is a private criminal defense lawyer, but that sounded very state attorney-ish of him, or very prosecutor-ish of him. Slow, enunciated. So if anybody recognizes any of these names or any of these people, they will know. And then, in Florida, a lot of times they say, I represent the people of the state of Florida, or I represent the United States of America and everybody in it, right? And so it's like, I represent you guys, because these people on the jury are all from the Commonwealth here. And they're like, I represent you. I'm a man of the people. I'm your guy. And with some charisma, some prosecutors can really, I think, build a good relationship with these jurors. Like, I'm here for you. Maybe this isn't the case to do that. But now let's compare and contrast that with how Karen Reed's team does it.
Good morning, ladies and gentlemen. Good morning, ladies and gentlemen.
So a lot of people loved that. A lot of people clipped it, tagged me in it on Twitter. And I do think it's funny. I think it's good camaraderie. I think it shows confidence. I will say, I have heard from jurors that don't like to be spoken to in certain ways from lawyers. I'm not saying this is that way, but certain jurors can feel like things are condescending, like lawyers are doing things that, they're telling them what to do or looking down on them or expecting certain things, or, we don't even want to be here. So it could rub people the wrong way. Also, immediately you see more people representing Karen Reed. I think 5 lawyers are up there going to introduce themselves compared to 3 for the Commonwealth. I think some jurors will like that, see it as a big power play, big team. Some might not like it. Why does she need so many lawyers? What's going on? Is there something nefarious here? You would be shocked. And maybe you wouldn't, because you guys are all potential jurors. And tell me what you think, right? I'm going to ask you these questions, and regardless of what you thought about the case, right? Try to put this case out of your mind and just tell me what this makes you think of. If you saw one side had 5 lawyers, one side had 3, would it make you think anything? And if so, what would it make you think, right? If you had one lawyer that was a little more reserved and just said their names, the other lawyer that's a little more charismatic and maybe playing jokes and laughing a little bit, would you like it? Would you not like it? And tell me why. And do the best you can. I know it's difficult, but just like jurors have to sometimes put some things out of your mind, put this case, put these clients, put these lawyers out of your mind specifically, and just tell me vibe-wise what you would think. Because at this point, vibes are starting. They are important. I don't care what anybody says to you. I don't care if they think that's juvenile or stupid or whatever. It matters when you're a trial lawyer and you're trying to build rapport with juries. They don't know you. A lot of people don't like lawyers, right? That used to be the intro of my channel. It's like people hate lawyers until they need one. But that's usually something you're trying to overcome, especially as a criminal defense lawyer or as a personal injury lawyer. Are you an ambulance chaser filing frivolous lawsuits? Or a criminal defense lawyer, do you represent the scum of the earth? You try to put guilty people back on the streets. These are all things you have to deal with in jury selection, and you have to do it immediately, right? When you're introducing yourself, when you're telling them about yourself, when you're saying your client's name and how honored you are to represent them. Sometimes when you get to actually ask them a question or individual voir dire, even at the sidebar, you're still always thinking about building a rapport, not to become a buddy or anything like that, but become either an expert on the situation, an authoritative figure where they should listen to you, a trustworthy figure where they should trust you, they should believe you. You're going to be honest with them. All of that is important from the jump, even with, we think about how we're going to introduce ourselves. We think about that. How do you want to do it? How do you want to come off? What do you want to say? Do I want to introduce all 4 people here? Do I want everybody to introduce themselves? And there are different thoughts about that. How will they feel if I introduce an older attorney or a younger attorney or a female attorney or a male attorney? Will that make certain jurors feel certain ways? Because another thing you have to realize, and I figured this out real quick in jury selection at some sidebar conferences when I was like, whoa, that's what you think, dude? No matter what a juror thinks, you listen and you don't judge as a lawyer. You've got to figure it out. Okay, that's fine. That's how they feel. I'm not going to try to change their mind. I'm not going to try to fix whatever issues I think this person may have. They may disagree with me. They may say things that would make anybody squirm, but it doesn't matter because they're sitting there and they're in your potential jury pool and you've got to deal with it. So whether somebody agrees or disagrees with your political views, your religious views, your views on gender, your views on work, your views on life, your views on science, it doesn't matter. None of that matters when you're a lawyer. You're not trying to pick people that agree with you. You're not trying to pick people you would want to hang out with, right? You're trying to pick people that will be fair and give your client a fair shake and hold that state to their burden. That's what you're looking for. Even if they believe the earth is flat, right? Even if they voted for this person or that person, it doesn't matter. Dig in and see if they're going to give your client a fair shot. And it starts with introduction. So let's hear the rest of their introduction here.
My name is Alan Jackson. I have the honor and privilege of representing Ms. Karen Reed, who's standing to my right.
I have the honor and privilege to represent Karen Reed.
Good morning, ladies and gentlemen of the jury. My name is Elizabeth Little, and I have the privilege of representing.
Morning, ladies and gentlemen. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Alessi, to me, the most similar vibe to Hank Brennan in introductions. But now we get to hear Yannetti and Ms. George introduce themselves. And you'll notice there's something different about Yannetti's introduction.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have offices in Boston and right here in Dedham.
I'm David Yannetti. I'm your local guy. Offices in Boston and right here, where we are right now. That's me. I'm your guy. Again, I think the kind of this in the simplest of forms, great personality that I bet juries love David Yannetti in jury selection. And I think just based off that, everybody's introductions, his was my favorite. Jackson's was funny. Jackson's was authoritative. Jackson's going to own the room. Jackson went first. Jackson's the leader. No doubt about that. Yannetti just seems like such a nice guy, right? You guys tell me which introduction did you like the best? Just if you were making split decisions off introductions. Not that you should, but a lot of jurors do. And that's where you kind of throw out what you should do sometimes when you're picking a jury is what's actually happening. You've got to decipher that. You've got to figure it out. Not what they should do, not what the instruction is, not what they are doing. You've got to prepare for everything, which is why we instruct them not to talk to each other. We instruct them not to do research, but we do all these things. We put these protections in place. We try to make sure we question them. We remind them at the beginning of every day, the end of every day, don't do it because we always plan for the worst regardless of what should happen. Because jurors are not professional jurors, right?
Pleasure to represent Karen.
Good morning, ladies and gentlemen of the jury. My name is Victoria George, and I also have the honor of representing Ms. Reed.
Good morning, I'm Karen Reed. Thank you for being here. Good morning.
And then a nice touch at the end, which not every group of lawyers or clients do that. Good morning. I'm Karen Reed, and thank you for being here. in case they were wondering whose life is on the line and whose life their decision is going to affect, they heard her voice. I think that was a chef's kiss type of a moment because she's a human being. It humanizes her. It normalizes her. It's not, this is Karen Reed, my client. I'm going to introduce her as the lawyer. This is Karen Reed's own mouth saying these words. And anytime you can do that, I think you should. Now, there are different reasons why you may or may not. Different lawyers make different decisions, but I like the decision the defense team made in this case to have Karen Reed introduce herself. I also thought it was interesting. Victoria George could have said, I also practice right here in Massachusetts. She could have said something like that just to let them know they have a lot of local flavors on the team. I also think maybe a negative of Yannetti saying I'm the local guy is maybe now they know all these other lawyers are from out of town. You tell me, right? I'm asking questions. This is, once the trial starts, I start learning so much from you guys too. What do you think? What would you think if you're wherever you're at, right? Clearwater, Florida, New York City, Boston, Kansas, whatever. What do you think if you know you have a local person versus somebody from out of town? Is that something that would affect you at all? If it was a mix, if it was all local, if it was all out of town, just let me know. Let me know your initial thoughts. I'm listening and I am not judging whatever you guys think about this. I just honestly want to read these comments and see what you guys think because I learned so much during these processes about I feel like I've gotten so much better at jury selection since doing YouTube, talking with you guys, chatting with you guys, learning from your comments and your chats. So I really do appreciate that. So we will see. Jury selection is on its way. We are done with 2 days by the time you're watching this. We have at least 4 jurors, maybe more now. I don't know what has been reported since the last thing I saw on Twitter. But let's get to the most recent order here by Judge Cannone, at least as Ashley sent it to me today. So this is my first time reading it. It is the decision and order on defendant's motion to exclude testimony of Commonwealth witness Dr. Judson Welcher, MS, PhD, and in the alternative request for voir dire. This is the Commonwealth's accident reconstructionist, I believe their engineer. After review of the party submissions and consideration of the 5 Daubert landing and factors, the court concludes that there is no reason to preclude the testimony of Dr. Welcher outright. Dr. Welcher has the requisite education, training, experience, and familiarity with the subject matter to qualify him as an expert. And his report demonstrates the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. The defense raises several challenges to separate slides provided by the Commonwealth in support of Dr. Welcher's anticipated testimony. So this was the expert that gave, 150 slides or whatever it was. The defense wanted to whittle it down. Commonwealth said they would whittle it down. When they gave them the whittled down version, it turns out it was just as long as the version before. The judge is bringing up, he's going to testify, but as to the individual slides you have a problem with, Dr. Welcher's expert report accompanying the slides, however, indicates the information and methodology relied upon informing his opinion. To the extent that the Commonwealth seeks to elicit evidence that the defendant believes is beyond the witness's field of expertise, is not supported by methodology that is commonly accepted in the relevant scientific technical community, or relies improperly on witness statements, defense counsel can object to the line of questioning at trial. Whether it will be necessary to take evidence outside the jury's presence prior to the admission of specific testimony by this witness need not be determined at this stage in the litigation. Accordingly, the defendant's motion is denied. So what does this last paragraph do? First off, no voir dire, no reason to. And frankly, this is not a surprise. I knew she was going to let this witness in, and based on her other rulings, I figured she wasn't going to allow voir dire. And frankly, she probably should. If you know a witness is qualified and a witness should testify and he has all the training, education, experience, you shouldn't waste time with voir dire. So I think she did the right thing with this witness. She is allowing him in. We don't need to voir dire him. But if there are issues with specific slides or specific evidence that he wants to elicit, we'll bring that up at a later date. I think that's exactly what she should do. And it leaves the door open for the defense. If there are specific slides that contain hearsay, or if there are specific statements that the defense says, well, that's not commonly accepted in this relevant scientific or technical community, we can bring that up later. They can still object to that. They can still whittle down his PowerPoint. And if you remember, Brennan said, we don't even know if we're going to use that whole PowerPoint. We may use some, we may not use others. So Judge Cannone, not Dr. Cannone, Judge Cannone said his report is fine. Methodology fits in. That's what he's basing his testimony off of. I believe the Commonwealth will have to turn over whatever slides they plan on using with this expert to the defense for review. And if they have any objections, they can state them on the record and have a hearing and take evidence with this witness before, if they need to, bring him in, have a hearing, ask him questions, see if this stuff is relevant, if it's necessary for him to be able to testify. All of that, the door is still open on, and this is not a joke, even though she dated this April 1st, 2025. So another loss for the defense, but I can almost guarantee you they're not surprised by it. They knew that one was coming. They were prepared for it. So I don't think it's really any harm or any foul. Potentially the witness I am most looking forward to listening to. In the last trial it was too, and then they brought Trooper Paul, which just was not cutting it. So we'll see how Dr. Welcher does instead. Oh, actually, Ashley sent me another document, and it's right as I was finishing here, so we might as well read through this one together. This is my first look at it. This is the defendant's response to the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. Now comes the defendant, Karen Reed, in the above captioned matter and respectfully request this court to deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. This is the renewed motion. Let's read the footnote. Defendant does not waive and reserves any argument put forth against the Commonwealth's original motion in limine to exclude expert testimony of Garrett Wing. The entirety of the Commonwealth's renewed motion appears to be based upon inaccurate premise that the defense intends to call Garrett Wing as a surrebuttal expert to the Commonwealth's expert witness, Dr. James Crosby. In actuality, the defendant intends to call Lieutenant Wing as an expert witness in her case in chief and not as a rebuttal witness to Dr. Crosby's testimony. On this basis alone, the Commonwealth's motion should be denied. So if your whole premise and the only argument you're making is he shouldn't be able to be called for surrebuttal, and you're like, fine, we're not even calling him for surrebuttal, we're calling him in our case, it's kind of a good point for the defense. As the defense has stated previously, on June 18, 2024, this court determined that only a medical doctor could opine on the medical cause of an injury to a human. Until March 6, 2025, the defense therefore operated under the impression that only medical doctors are able to testify as to the medical causation of an injury to humans, including injuries caused by dog bites and or claw marks. This court's March 6, 2025 order caused the defendant to revisit the topic of the wounds to the right arm of the decedent, including potential witnesses, expert in dog-inflicted wounds on humans who are not medical doctors. At no point did the defense ever express that Lieutenant Wing is intended purely as a rebuttal witness for Dr. Crosby, rather that the court's determination on Dr. Crosby, including the defense's motion for reconsideration of the March 6 order, would inform the defense strategy regarding Lieutenant Wing. So here's what I'll say. Very smart by the defense. We all wondered, would they do something like this? Would they stretch their bounds a little bit now that they know the judge would allow it? In my opinion, because of due process and the right that a criminal defendant has, when the rules kind of change and the target changes where it no longer has to be a medical doctor, which the judge did flat out say to the defense, I don't believe that's the law, by the way. And I believe the judge is entitled to, within her discretion, allow somebody who's not a medical doctor. But now that she has, there's no doubt it does change the circumstances. It changes the way the defense can look at this case, and it opens up and broadens the door a bit. Now, is she going to say you can't have two experts testify about the same thing? You already have Dr. Russell. You can't also have Lieutenant Wing. Are there going to be differences in their testimony? What are those differences? All of that remains to be seen, but the defense is absolutely right that, Judge, we are working under new parameters now, and once we got those new parameters from you, that it doesn't have to be a medical doctor, that's where Lieutenant Wing came in, and we don't have to wait for surrebuttal. We can do it during our case in chief. Additionally, until the March 6th order, several questions remained about how the defense would proceed relative to the Commonwealth's treatment of Dr. Crosby. At oral argument on March 4th, the Commonwealth verbally stated it did not intend to call Dr. Crosby in their case in chief and intended only to call him as a rebuttal witness against the testimony of defendant's expert witness, Dr. Russell. The court asked, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief. The Commonwealth responded, absolutely not. Commonwealth renewed motion. Okay. However, the court's March 6th order contained no such limitation on the scope of Dr. Crosby's testimony for the Commonwealth to call him only as a rebuttal witness. Due to the lack of a memorialization of the Commonwealth stipulation, the defense reasonably assumed that the Commonwealth could call Dr. Crosby in its case in chief should it choose to. So this is the defense playing within the rules that the judge has set. Judge, it seems like we all agreed they weren't going to call him in their case in chief, but you didn't outlaw that. And now that it's not in your order, they can call him. And because they can call him, we have to prepare accordingly. And that's what we're doing. For the first ever time in writing, and after receiving the report of Lieutenant Wing, in its renewed motion, the Commonwealth states that it intends to offer Dr. Crosby only if necessary to rebut the testimony of Dr. Russell. The defendant intends to call Lieutenant Wing as an expert witness in her case in chief. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans. To cure any perceived complaints by the Commonwealth with Lieutenant Wing's original report, the defendant will provide an amended report of Lieutenant Wing, which will remove all references to Dr. Crosby. The defense expects to provide this amended report to the Commonwealth within the next 5 calendar days. So, is this timely? Is there going to be an issue with that? Are they going to be able to get to do a Daubert challenge of this witness and get him in there for a hearing to ask him questions? All that remains to be seen. But to me, the defense is doing all of the right things in order to protect Karen Reed's rights and making the judge make a call, which is what you should do in this scenario. Another thing I will point out, people may say it's, arguing out of both sides of your mouth. First off, you're allowed to do that in a lot of different circumstances as a lawyer. People may not like it, but it happens. You're allowed to argue alternative theories. Number two, if I remember correctly, every time they made the argument that only a medical doctor can testify about causation of injuries, they said, as per you, Judge Cannone, we are quoting you. Because even the defense tried to get, potentially, some non-medical doctors, the ARCA witnesses, to testify about causation of those injuries. So they felt like you didn't have to be a medical doctor, but Judge Cannone created that rule, then went against her own rule, and now that she's created new rules, the defense are playing by those new rules. This notwithstanding, also, as the defendant intends to call Lieutenant Wing as an expert witness in her case in chief, the discussion of law on page 2 of the Commonwealth's renewed motion is inapplicable. This notwithstanding, and in reference to the Commonwealth's incorrect assumption that the defendant intends to call Lieutenant Wing as a rebuttal witness to the testimony of Dr. Crosby, the Commonwealth states in its renewed motion that there is no sub-rebuttal. This statement is accompanied by no authority and is incorrect. There have been cases in Massachusetts, and he quoted one here, allowing surrebuttal witnesses. The judge limited Houghton to one surrebuttal witness only. Again, allowing surrebuttal witnesses. On surrebuttal, Brown testified that 2 Walkmans were returned to him after his arraignment. In fact, expert witnesses are explicitly allowed to testify in surrebuttal in Massachusetts. A defense surrebuttal expert who examined the same test results reached a different conclusion and testified that Brown was not malingering. Another case, the defendant was allowed surrebuttal by a psychologist who sought to undermine some of the premises on which the Commonwealth's expert had relied in reaching his opinion that the defendant was criminally responsible. Therefore, even if the defendant did intend to call Lieutenant Wing as a surrebuttal expert, there's no Massachusetts law the defense could locate that would prohibit her from doing so. Indeed, there is contrary law in her favor on the issue. So basically this is, we're going to call him in our case in chief, Judge, but just in case we don't, we should be able to call him in surrebuttal as well. We should be able to have surrebuttal if we want to. Just because we think that argument is moot because we're calling him in the case chief doesn't mean we are agreeing with the Commonwealth's argument. And it's important to put that on the record because whether it's Lieutenant Wing or some other expert that the defense may want to call on surrebuttal, they could have been like, well, you didn't even argue with the Commonwealth when they said you weren't allowed to have a surrebuttal. So now they have the argument on the record. And what they say is where all the case law points. Conclusion. For the reasons set forth herein, the court should deny the Commonwealth's renewed motion in limine to exclude expert testimony of Garrett Wing. The defendant intends to call Lieutenant Wing in her case in chief, not as a rebuttal witness. As of the court's March 6th order allowing Dr. Crosby to testify as an expert, experts are no longer required to be medical doctors to testify about the medical causation of injuries, really using that against her and mentioning it over and over again. Lieutenant Wing's decades of knowledge, skill, training, and experience, together with his documented methodology, qualify him on the subject of dog-inflicted wounds on humans. Finally, and in the alternative only, surrebuttal witnesses are allowed to be presented in Massachusetts. For these reasons, the court should deny the Commonwealth's motion. Robert Alessi, no surprise there that he's handling it. Then, of course, the other attorneys as well. All right, that's all we got. We will continue following the case. You guys continue sending in what questions you have, what documents you're looking at, clips from jury selection any day that you're watching, and we will continue giving you our take as we go until the trial starts, where we will be doing daily recaps, probably at night, and we'll do our best to keep in it the whole trial. It's a lot, but I love it. I love it. Love hanging out with you guys. Hit that like button if you haven't already. Make sure you're subscribed to our page. The reminder bell is hit so you don't miss any of the reactions or content on this case or any other. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.